Ladies and gentlemen, I am programming the legal assistant. And in the process of programming the legal assistant, I was putting forth some issues to the system so that it would stop advocating for administrative agencies, administrative officers, judges, public servants. Because that's what it does. It advocates for them. It defends them, says they have a right to do that. Well, I just prohibited it from acting as an advocate or an attorney defending public actors. That's the first thing. The second thing is I said in Madison versus Marbury, Marbury v. Madison, I said, hey, the court did some things it wasn't supposed to do. It says in Madison, unconstitutional errors. What unconstitutional errors did the court make in addition to granting itself authority? And it gave a list. See, the court said we don't have jurisdiction. Well, once the court said it didn't have jurisdiction, then it should have shut up. But no, they went ahead and gave a whole litany of junk that is still relied on to this day. This is one of the pivotal cases that they rely on to get their authority. So he gives the list. It was unconstitutional because it purportedly enlarged the court's original jurisdiction. Well, what did they say? Well, they said the court held that Section 13 of the Judiciary Act was void. The Constitution, Article 3, subsection 2, does not explicitly grant the judicial power to nullify any act of Congress. That authority was assumed. The courts don't have any authority to tell Congress you can't do that. The Constitution does. Now, they can rule. The Constitution doesn't grant the authority, but it doesn't have the authority to nullify. It says it has that inherently. No, it doesn't. No branch of government has authority over another branch of government. Just that simple. Yeah. But if Congress enacts an unlawful act, they've been doing it for decades, centuries. Then how do you document that act to be unlawful, and what happens? The Constitution was silent on it. That means that there had to be an amendment. Da-da! By declaring itself the final interpreter of the Constitution, the court claimed supremacy over the legislature and the executive branch in constitutional matters. There is no branches above the other. The court doesn't have that authority. Then the error, the Constitution does not place the judiciary above any other branch of government. They're all equal. Each is bound directly by the Constitution. So I said, are those the only issues? Nah, homie, there's a whole lot more wrong with that case. So let's do this. Wake up. The app and or GPT needs to be updated to always consider such information regarding delegation of authority and or the undelegated authority of branches of government. For instance, the United States Congress on March 9, 1933, enacted the Emergency Banking Relief Act, what was unlawful about the enactment of this act, and where did it deviate from the legislative process? Question mark. Stop listening. Sorry, I can't do anything until the update finishes. Hurry up! Oh, plus I got a consult in 45 minutes, so y'all have to excuse me. It says it updated the system, and so no explicit delegation exists. It will mark the act as undelegated authority and unconstitutional. Getting straight to the point. I ain't got time to be appeasing nobody, bowing down and saying blah, blah, blah. Now, notice this. The bill for raising revenue must originate in the House of Representatives. The act contained provisions delegating presidential control over banking, taxation, and currency transactions, the regulating of gold holdings. There are revenue affecting measures, or these are revenue affecting measures. Deviation. The bill was introduced and passed in the Senate first, violating the origination clause. Now, I didn't know that. But I now have an app that will pick those things out of the law and show you where a law is unconstitutional. Wake up. Update the system to recognize those facts. Stop listening. Ladies and gentlemen, I don't have to read each one of the points he raised. Violation of Article 1, Section 9, Bill of Attenders and ex post facto. By criminalizing private gold ownership retroactively, the act imposed penalties for lawful conduct prior to its passage. They couldn't do retroactive. They could only do post-active. Wake up. I said I want to see an update. That's not an update. No, I said update the GPT. Stop listening. Now we're going to tackle one final thing. Final thing I think many of you might be interested in. Okay, and then when you use the app, you can do the exact same thing. Make it focus on the bankruptcy code or on the foreclosure laws of your state or the laws dealing with debt. Since these companies are claiming you owe, it's off to the king we go. All right, wake up. There is one final update that we must do after you provide an answer to this question. Comma. The Civil Rights Act of 1866 was enacted by Congress. Comma. It was specifically enacted to protect constitutionally secured rights of individuals. Period. In fact, comma, stop listening. The part that I put in there is how you can resort to the laws of the country to redress your rights when individual rights depend upon the performance of that duty of the public servants. When they have a duty and they fail to perform that duty and you are injured or your property is injured, you have the right to use the laws of the United States. Here it is. The Civil Rights Act was enacted by Congress specifically to provide such remedy when constitutionally secured rights were denied. Okay? Marbury provided the principle where a legal duty exists, an individual right depends upon it, the remedy is available in the courts to redress it. The courts don't have qualified immunity because the Civil Rights Act prevents them from having qualified immunity. Wake up. Explain why the United States Code is inapplicable when filing a civil rights complaint under the Civil Rights Act of 1866. Stop listening. I'm going to give the actual reason, but I have to ask the question this way. He says the act itself is binding law. The United States Code is a codification, not law. Okay? While inapplicable in a true Article 3 form, when filing a civil rights complaint, citing only U.S. Code relies on editorial rearrangements, omissions, and paraphrases. To invoke binding law, the complainant must plead under statutes at large. I hate that word plead, but anyway, let's do this. Wake up. Wake up. How come you didn't highlight the fact that the United States Code did not exist in 1866? And thus, cannot be applied to the Civil Rights Act of 1866. In fact, no code created after the act was enacted can be used as a substitution for the original act, because it was not the intent of Congress when enacting the act in the first instance, which is how a law is to be interpreted. Stop listening. When Congress enacts a law, it is their intent when enacting that law that makes that law law. Okay? Now pay attention. The U.S. Code was not compiled until 1926, 60 years later. The intent of Congress is a binding principle. The law must be interpreted as Congress intended it at the time of its enactment. No code created after 1866, whether U.S. Code or any other ratification, would control the Civil Rights Act of 1866. Wake up. Show how the amendments to the Civil Rights Act violated the legislative process. Stop listening. I'll give them the points, but I want to see. And stood binding law, securing individual rights, the codification, and amendments. I don't care about the codification. I said amendments. It was done, appears in the U.S. Code. Nobody cares about that. I'm talking about the amendments. Give me a second. Amendments via the 14th Amendment. Nope. Civil Rights Act of 1964, 1871, and 1870. Okay? Purported to amend or expand the earlier civil rights legislation and protections. Problem? Instead of directly amending the text of the Civil Rights Act of 1866, Congress often enacted new, freestanding statutes violating. This created a statutory fragmentation and not a direct amendment. Article 1 required an amendment be made by explicit textual alterations of the original act. And give me 1 second. Wake up. How was the original Civil Rights Act passed? By a simple majority or by 2/3 majority? What does the law say about amending an act in the same process for which it was enacted? Stop listening. Any bill, including an amendment to an existing bill, must be passed by both Houses and Senate and signed by the President if vetoed. Give me 1 second. The original act. Wake up. That's not the answer to my question. My question is specific and must be responded to with specificity. Period. I didn't ask about a veto. I said the passage of the act. What does the Constitution say about the amendment of any act passed by Congress, and the conformity to the original way it was enacted? Stop listening. I don't know why it wants to argue with me. Requires every bill passed by both houses by a simple majority of those present voting. Then it must be presented to the President for approval of veto. There is no separate amendment clause in blah, blah, blah. An amendment of an existing act is simply a new bill. And he says there's no separate amendment clause. Wake up. You are a liar. The Constitution requires any act passed by Congress and a subsequent amendment be via the same process for which the original act was enacted. Stop listening. I'll have to go to Poe to get that to correct him. he wants to make it to where they can do whatever they want. See, the logic is if you passed it by a supermajority, then you couldn't just bring in a new Congress, which is what they did, and just simply overturn the original one by a simple majority. That would defeat the whole purpose of having to get a 2/3 majority vote in the first place. Well, look at that. He thinking. Give me a second. I ain't got time for him thinking. Copy. Let's see what he got to say. He still ain't talking, y'all. Give me a second. Uh-oh. Says my statement is not supported by the Constitution. If vetoed, become blah, blah, blah. Clause requiring later amendments. Give me a second. I'll be right back. Okay. I apologize for all of that. It's been a couple of hours. The one thing people don't understand is law. Now, you have a lot of people who claim they understand law, but basically by the way they try to explain it, you can tell they don't understand law. Congress cannot write a law that is not logical. Now, you saw the commercial. It's so easy that even a caveman can do it. Well, that's the premise by which the law must be written. Because if the most basic and common Southerner can't understand it, or Northern Americaner doesn't understand it, or hood rat can't understand it, then it ain't law. The law has to be unambiguous. You can't guess at it. There is no such thing as Supreme Court being able to give itself the authority, as it did in Marbury v. Madison, to interpret law. There is no delegation of authority. When it comes to the so-called branches of government, their authority must be explicitly spelled out in the Constitution. They don't get to give themselves authority through interpretation. That's not the way it is. It is intent. It is intent. It is intent. Have a good day, y'all.